Mr. Sminya.
Good morning, Chairperson. Good morning, Commissioner Mabena. We have reserved in the main SERI to lead its evidence this week. I take it they will be having the evidence of Ms. Zondo for this morning. And if indeed so, I would be swearing her in.
Yes.
Chairperson, Commissioner Mabena, just to confirm that that is indeed so and the witness is available.
Thank you.
Please give us your full names. Good morning to you, Ms. Zondo.
Good morning, Alfred Sminya. It's Nomzamo Zondo.
Do you swear the evidence you're about to give us will be the truth, nothing else but the truth? And if you do, please raise your right hand and say, "So help me God."
So help me God.
The witness is sworn in.
Thank you, Mr. Sminya. Mr. Bricky, your witness.
Thank you, Chairperson, Commissioner Mabena. Good morning, Ms. Zondo.
Good morning, Advocate Bricky.
If I could please take you to the bundle entitled Index to SERI Evidence, Part B bundle, and file 1 of that bundle. Do you have the file?
I have the file.
And if I could take you to page 1 of that bundle, it reads, Affidavit of Nomzamo Zondo on behalf of the Socioeconomic Rights Institute of South Africa. Do you have the document?
Yes, I do.
It runs to approximately 150 pages, but if I could take you to page 5, paragraph 1.
I have it, Advocate Bricky.
That identifies you as an adult woman attorney and the executive director of SERI. Is that correct?
That is correct.
And then if I could take you, please, to the end of the statement at page 145. Your name, it's page 145.
I have it as well.
Your name appears, this is the signature page, and the oath is given there, indicating that this statement was signed in Braamfontein on 16 May 2024. Your name appears, and there's a signature above that name. Can you confirm that that signature is yours?
I confirm that the signature is mine, and I depose the affidavit.
Now, if we remain on that page, in paragraph 336, you say in the statement, as appears above, some of the information is research-based and thus was produced by SERI's research team led by Lauren Royston.
I see that.
And it continues, to the extent that I may be permitted to give evidence at the Commission, and insofar as some of the issues to be addressed will require an in-depth discussion of the research aspects, then Lauren Royston will also be available to deal with those aspects.
I confirm.
And over the page, on page 146 and following, there appears a confirmatory affidavit by Ms. Lauren Royston.
That is correct.
So if we return then to your main statement, which runs, as we've seen, to 145 pages, you've indicated that parts of that statement draw on the knowledge and expertise of Ms. Royston. Is that the correct position?
Yes, that is correct.
And Chairperson Commissioner Mabena, for the record, SERI intends to lead Ms. Royston separately as a witness tomorrow.
Yes.
Ms. Zondo, If we can turn then, or let me ask you in general terms this way. Which aspects of the statement draw in particular on the expertise of Ms. Royston?
For an example, there is an aspect that looks into the quality of life of inner city residents. So that aspect will be covered by Ms. Royston. There is an aspect that covers the City of Johannesburg's policies on the inner city. That aspect will be covered by Ms. Royston. There is also an aspect that looks into series research on clients that it has represented and how they came to occupation of buildings and their circumstances. Ms. Royston will also cover that aspect.
Thank you. If we can return then to your own position, you are an admitted attorney. When were you admitted as an attorney?
I was admitted in November of 2008, Chair.
And when did you join SERI as an employee?
I joined SERI as an employee, Chairperson and Commissioner Mabena, on the 1st of February 2013.
And you indicate in paragraph 2 of your statement, as you say, that you joined SERI on that date and that you were subsequently appointed as SERI's Director of Litigation. Can you explain the roles that you held subsequent to being an attorney?
Thank you. In July 2014, I was promoted to be the Director of Litigation, having the responsibility of managing all of SERI's litigation. And on the 1st of January 2020, I was appointed as SERI's Executive Director, which is the position that I hold even today.
So you've been at SERI for just over 10 years, and you've been the Executive Director since 2020.
That is correct.
The next section of your statement from page... sorry, there's one further confirmatory we should just reference. We've looked at, if I can take you to paragraph 5, you've referred there to Ms. Royston's knowledge and her confirmatory affidavit, which we've seen at page 146. You refer further to a confirmatory affidavit of Siyabonga Mahlangu, and that is annexure NZ2 to your affidavit.
Yes, as SERI represents itself in this commission and the Inner City Federation, the information that is in the affidavit contains information that is also within the knowledge of Mr. Mahlangu from the Inner City Federation.
And that confirmatory affidavit of Mr. Mahlangu appears at page 150 and 151 of the bundle.
I can confirm that.
If we can come then to the Commission and SERI's role, and you've indicated that SERI represents the ICF and also appears in its own name. Could I take you to page 7 of the statement and paragraph 12?
I'm there.
That paragraph records that SERI did not at any point represent the people who lived at Usindiso building and does not and has not represented the survivors. Could you comment on that, please?
I can confirm that SERI has not represented the residents of Usindiso. I can confirm definitely that in the 11 years that I've been at SERI, they were not clients of SERI's, or even now.
And in paragraph 13, you record what you've already explained, that SERI represents itself as an entity and also represents the ICF. And in paragraph 14, you comment on SERI and the ICF's interest in the proceedings, relating mainly to the systemic issues. Could you please comment on that for the Chairperson and Commissioner?
Thank you. Chairperson, Commissioner, SERI has been involved in representing occupiers of the inner city of Johannesburg since 2010. We have also represented informal workers within the inner city. And when the circumstances arose of the tragedy of Usindiso, we were firstly concerned, but also we understood once the commission was appointed that some of the issues the commission will deal with are issues that SERI has specialized information and experience that it should bring to this commission. That's why we felt it was important to come and participate.
And in paragraph 15, you describe some of the participation to date in the commission by SERI, the specific aspects of the proceedings.
I confirm that.
In from paragraph 16 onwards, you provide an overview of SERI's contribution now to part 2 of the Commission, referring in paragraph 17 to aspects of the terms of reference, and in paragraph 18 summarizing your statement of 145 pages.
That is correct.
So to situate ourselves in paragraph 18, you indicate that your affidavit deals with SERI and its work, SERI's interpretation of the terms of reference, inner city housing policies, the city's obligations pertaining to the provision of basic services, the city's role in the inner city viewed with the development of law pertaining to housing rights, housing affordability, the process of occupation, people residing in occupied buildings, access to basic services in occupied buildings, the unique experiences of women, and then finally in the final 4 subparts, findings to be made in part 2, lessons to be taken, steps to be taken and by whom, and a conclusion. So if I may, we'll begin then with SERI and its work, from page 10, paragraph 19, where you provide an overview of SERI and its areas of focus. In paragraph 19, you describe SERI as a registered non-profit organization and public interest law clinic. Could you please explain the nature of SERI, its work, and how it operates?
Thank you. SERI was founded in 2010. And from 2010, it was founded to really support the agency of marginalized people and communities who are fighting inequality and also who are fighting for the realization of their socioeconomic rights. And in doing that work, SERI provides both legal, research, and advocacy expertise to those activists, communities, and movements. And we've done that in a number of ways. So one of the ways is that I registered a law clinic. We are registered as a law clinic with the Legal Practice Council. We were previously registered with the Law Society before the LPC came into effect. We do provide research which looks both at issues that affect our clients and also outlines their experiences.
So you've explained that SERI's work includes litigation, research, and advocacy. Could you say a little bit more about how those interact and how SERI is structured to do that work?
Thank you. SERI as an organization has 3 departments. It has a litigation department, which is led by its Director of Litigation, Advocate Brickhill. It has a research and advocacy department, which is led by Ms. Royston. And those departments work together across 3 themes that SERI works on. The 3 themes include the first theme, which engages the work of this commission, which is securing a home. And in that work, we represent and act in relation to inner city residents, informal settlement residents, and other people who are fighting for secure tenure and access to basic services across the country. And in that area, we also support movements that include the Inner City Federation, Abahlali Basemjondolo, and others. We also do work that supports informal and precarious work in an area that we call making a living. And in that area of work, one of the notable things that we've done, for instance, is we've acted for domestic workers, and in 2020, we're successful in getting a section of the COIDA Act declared unconstitutional, which brought into enjoyment of the COIDA protections close to 1 million domestic workers. We also do work in an area that we call expanding political space, and within that work, our focus, we focus on 3 issues. One is ending police impunity. The second one is to divert the silencing of dissent, and the last one is in making sure that people can access can exercise the right to protest. And again, in that area, I think our most visible work would be our representation of the families of the 36 deceased mine workers who were killed in Marikana in 2012. And that area of our work actually is one of the things that we feel bring together the work that we do, because core to SERI's mission is making sure that the agency of the people that we represent is respected. And insofar as this commission, for instance, comes in, part of the questions of where people live, we feel is a choice that they should be able to make. And we also feel principally that our history makes those questions important, because we know that what built apartheid, what fortified apartheid, was three aspects of land dispossession, of disenfranchisement of the black majority, or the African majority, and then a racial allocation of resources. And within that tripartite operation, apartheid was able to subdue the African majority. And so in SERI's work, part of our work is making sure that the African majority, especially those who are poor and marginalized, can have their choices respected and can have their constitutional rights realized.
Thank you, Ms. Zondo. In paragraph 21 of your statement on page 11, you introduced those three thematic areas that you've now explained: securing a home, making a living, and expanding political space. And you've given some examples. Could you give a sense of the relative weight or priority of those three areas across SERI's operations?
Thank you. So in terms of SERI's experience, from the beginning, SERI focused on representing people who are fighting, either were trying to defend themselves against eviction or trying to fight for access to basic services in informal settlements. As a result, I always estimate that 3 days in the week, SERI spends representing, researching, advocating up on that area of work. The components on making a living and expanding political space have been growing more and more within SERI's work, and also, as I've said, they've also grown in prominence as SERI has also itself grown.
Thank you. In the next two sections of the statement, you outline SERI's relevant publications and then SERI's litigation. On the question of the publications, you've explained that Ms. Royston leads the research and advocacy team, and those publications would come out under her responsibility.
Indeed, but I would like to just highlight, for instance, that in those publications, one of the reports that SERI prepared is a report that appears at paragraph 22.2.2. And that research report was entitled Minding the Gap, an analysis of the supply and demand for low-income rental accommodation in the inner city of Johannesburg, which we published in 2013. And in that research report, we are outlining the scarcity of affordable rental across the inner city. And in publishing and disseminating that report, we engaged the city, we engaged other government stakeholders. I just want to say that in raising these issues, we've continued to raise them for a very, very long time. To say that even in 2013, we're already raising this issue in a concrete way.
If I can take you half a step backwards, and if you could just explain to the Commission how these publications and SERI's litigation work relate to one another.
Thank you, Chairperson. Thank you, Madam Commissioner. So SERI's work is really meant to answer the challenges that our partner and client communities are struggling with. And therefore, most of the time, the research questions, in fact, all of the time, the research questions come from the experience of our clients and times from the experience of our litigation. And so Minding the Gap is an example of, in our experience of litigating to defend unlawful occupiers in the inner city of Johannesburg and fight for the provision of alternative accommodation, we kept getting stuck. We were getting stuck firstly in the provision of temporary emergency accommodation, but also in the question of what happens to them once they're in their temporary emergency accommodation. And we saw, I think in the research, working with our clients, we went and said, okay, what are the challenges? And we're able to find them. And again, the way, because the team has a synergy, you find that some questions start off through litigation, other questions start off through research. And I'll give another example, which falls outside of the Commission of Inquiry, which was the community that we represent in Nansfield, close to El Dorado Park, in Slovo Park, where that community had worked with our research team to look at their challenges on getting their informal settlement upgraded. And that research project had gone, I think, for 2 years. And that community then approached us to say, actually, can you litigate on our behalf to make sure the state upgrades our informal settlement? And that case was litigated, I think, for about 3 years. And in 2016, there was a court order that ordered the city of Johannesburg to provide, to make a decision to upgrade the informal settlement, and also engage the province as the party that's responsible for that policy. So there's, I always say there's a dance that happens between the two teams.
And if you could, we've listed and annexed some 14 research publications as annexures NZ3 to NZ14 to your statement. I don't propose, and you've highlighted the Minding the Gap publication, but could you give a sense of the types of research publications that SERI has produced?
I don't want to look at Ms. Royston at this exact moment. But in the research reports that SERI has produced over time, we have, for instance, produced reports that look at government policy and their implementation. We've also produced reports that look at the experiences of our clients in organizing and mobilizing on their issues. So, for instance, in the list, we include a publication on the establishment and the English word now escapes me, and the operation of the Inner City Federation.
That would be, sorry to interrupt you, at paragraph 22.2.1, annexure NZ10. Inner City Federation fighting for decent housing in inner city Johannesburg.
Yes, precisely. We also do legal research. And so, for instance, in the list, there is a 22.1.4, a report that looks at the jurisprudence on evictions and the provision of alternative accommodation, and advocates to local government on how they should respond to those cases. And in doing that, in having done that research, in all of our research products, we don't only just publish, but we have a dissemination strategy, we have an advocacy strategy. And at all times, we've tried to engage all segments of the state, from local up to national.
Thank you. Perhaps we can take you closer to your domain then, in litigation, from paragraph 23. Where you introduce SERI's litigation, and in particular, its litigation in the inner city. And you describe how SERI has represented people living in the inner city since 2010, and currently represents residents living in 37 properties in Region F, and provide an estimate of the number of buildings in which SERI has consulted with residents in the past. Could you speak to that paragraph 23? And SERI's litigation work in the inner city.
Thank you, Chairperson. Thank you, Madam Commissioner. So in the course of SERI's work, we are approached by communities to represent them. At times, that is either because they are facing the threat of eviction, sometimes they've been unlawfully evicted, sometimes they are struggling with access to basic services. And in that, as the paragraph explains, we currently have 37 properties within Region F. In those 37 properties, I know that there's about 16 properties that we've acted for more than 10 years. And in SERI's law clinic also has consults with potential clients, with members of the public who are struggling with different issues on a daily basis. So I even believe that the number that we've put of 100 is extremely conservative. It would be much higher than that, because people within the inner city who are struggling with these type of challenges would most of the time be advised to come and consult SERI.
And you indicate in the final sentence that SERI represents communities also living in informal settlements in Johannesburg and Durban. Could you give a sense of that work?
Thank you. SERI has partnered with Abahlali Basemjondolo, I think since it was established. And Abahlali organizes in KZN, they organize in Mpumalanga, in the Eastern Cape and the Western Cape. And some of the cases that we work on in informal settlements are cases that were referred to us through their office, through their advice office. In Johannesburg, I mentioned already the community of Slovo Park, but there are other informal settlements in Johannesburg who are represented by SERI. And I think as well in the Western Cape, I think before the case that we did supporting domestic workers, the biggest case we did, we represented the residents of Marikana and Philippi in Cape Town, who were all, again, they were opposing an eviction. But in the end, we were successful in opposing the eviction, but also starting a process where that 60,000 strong informal settlement can be upgraded and provide formal housing.
You've now mentioned Cape Town and that example of Marikana and Philippi, and your statement refers to work in Durban. Which geographical areas does SERI litigate in, and in particular relevant to the issues that the Commission is faced with, housing and services?
So SERI has, I think, represented people in definitely in the three big metros, being Johannesburg, Durban, and Cape Town. On the issue of housing, including Ekurhuleni, SERI is practices across the country. I think the only province that at this point I can say we've never had clients in is Limpopo, but we've acted in the 8 provinces in housing matters, in matters involving informal and precarious workers. And so our spread is actually, our work is national.
In paragraph 25, you describe the categories, the types of residents or occupiers that SERI has represented in housing matters. You say that the majority are unlawful occupiers, but there are also some other categories. Could you identify those categories in 25.1 to 3?
Thank you. I think unlike the circumstances across the country, most African people have no right to property. And I think SERI's work speaks to that. I think the example of saying most of our clients are unlawful occupiers. But some of them, as I've explained, as you've raised in the question, were provided temporary emergency accommodation by the city of Johannesburg and are therefore lawful occupiers who are there in the buildings with the consent of the city of Johannesburg. Some of them, I think Mr. Ketani came to give evidence here, moved in 2008. Others, the last group that was accommodated by the city would have moved, I think, in 2022. Currently, SERI acts for the residents of 8 of the 11 properties that were provided as temporary emergency accommodation by the city of Johannesburg. We also assist in rental disputes. Our Kenda attorneys attend to the Rental Housing Tribunal. We've done work, at least there's 2 major cases that focused on issues that related to rental, specifically the exercise of the landlord's powers of cancellation. One in a case that involved actually both landlords had decided to renovate the properties and then wanted to cancel the leases. One of them wanted to increase the rental exponentially. The other one sought eviction, but the ultimate outcome was the tripling of rental, which meant that the tenants could not afford it. And then there is a much smaller portion of clients who are property owners who would have either bought units in the inner city of Johannesburg in the late 90s, early 2000s, or would have been assisted by the state through state subsidies to purchase such units. So within SERI's litigation practice, we represented at some point the former occupiers of Fetis mansions who were owners and they were evicted. We represent currently the owners of Wellington Court, another property in Joburg Park. And that segment, I always say to the team, are the beneficiaries of the Mandela houses. Because in the 90s, there was that attempt to ensure that inner city residents can live in the inner city, and many of them got assistance through that.
Now, in paragraph 26, you refer to, as you've commented on now, Seri representing residents in 8 of the 11 temporary emergency accommodation facilities. How did that come about, that Seri represents those residents?
So one of the facts that comes up later in the affidavit is that the city of Johannesburg has not provided temporary emergency accommodation to anyone, barring one circumstance, without a court order having ordered them to. And so the reason why Seri then represents 8 of the 11 is because in those 8 cases there was litigation, firstly, for people to be evicted, where there was interventions to make sure that they are protected from the consequences of that eviction. And then there were court orders, and then unfortunately again, there had to be attempts to enforce those court orders, which then ultimately led to the provision of temporary emergency accommodation to those groups. And the one example that I said is an exception had gone through the very same process. The only exception is that the temporary emergency accommodation was provided because there was a fire at that building at a time when they'd been waiting for the provision of accommodation for more than 2 years. So there'd already been a court order that must be provided with accommodation. It wasn't provided. And then I think it was in April 2020, there was a fire in the building, and it was the height of COVID. And the city of Johannesburg, to be quite fair to them, cooperated with us and quite quickly provided the accommodation at 833 Albert Street to the former residents of Ingelosi House.
That's the former residents of Ingelosi House.
Ingelosi House, yes.
For completeness, we're dealing with an urban context here, but just for completeness, does Seri assist clients in rural settings, in particular in relation to housing, land, services?
So one of the key partners that Seri represents, Chairperson and Commissioner Mabena, is a farm workers trade union. They are based in the rural Western Cape in the farmlands. It's called CASAU. In short, I won't go into I won't break down the acronym. In many of those cases, we represent farm dwellers and farm workers who are being evicted by farm owners. In relation to, I think, our other work in the rural setting, where it's been most visible, has been our representation of the Marikana families, who are mostly from the rural Eastern Cape.
If we return then to your statement, from paragraph 27, you provide some examples of court decisions in which Seri acted. And the first category in 27.1 refers to inner city evictions and access to alternative accommodation. And you mentioned the Blue Moonlight case, Changing Tides, Dladla, and several other judgments. Do you have any comment to add in relation to that category of judgments, including your own personal involvement, if relevant?
Thank you. So before my time, Seri was involved in enforcing the Constitutional Court's order in Blue Moonlight for the group that became the residents of the Ekutuleni Shelter and MBV Phase 2. When I joined Seri, the former director of litigation, who is now an advocate Tebogo Masikili, was the attorney of record for the residents of Changwa Mansions. But by the time I took over as director of litigation, he had gone into practice. And I was responsible in enforcing, in firstly bringing the application to get a mandamus to compel the city officials to comply with an order of the High Court which ordered them to provide accommodation to the residents of Changwa by June 2012. So that had been appealed to the SCA. I was involved in that appeal. I was then ultimately involved in the enforcement of that order. There were, I think, there was, outside of the mandamus application to compel the city officials to execute the order, there was a contempt application brought because as of 2015, there was still no accommodation in sight. And accommodation was then provided to our clients on the 9th of January 2016. So I was involved in that, and Seri also produced a short film titled The Road Home, which is available on a YouTube page that Seri runs, which tells the story of that community. When I joined Seri, taking over from my colleague, Mr. Mngomezulu, he had represented the Ekutuleni community in bringing and launching the Dladla case, which also became, I think, a case that ended up before the Constitutional Court on the conditions that the City of Johannesburg can impose in temporary emergency accommodation facilities. Maybe I'll stop. I'll stop there. I don't want to take too much time.
And so you've mentioned your involvement in the first three of those matters, and the Dladla in the third matter, that is the applicant there is Ms. Ellen Dladla, who has also provided a statement in these proceedings. Is that correct?
That is correct. She was one of the 33 and the main deponent throughout that litigation from 2012 October to when we finalized it in 2017.
So in 27.1, that's a set of examples of cases relating to inner city evictions and alternative accommodation. In 27.2, there are examples of decisions relating to informal settlements, and you've spoken to that work. Is there anything that you would add in relation to those judgments at this stage?
I think I would just highlight the case of Tubakale and others versus Ekurhuleni, which is one of the cases that I've personally worked on since I joined SERI, and have had the experience, which is quite similar to the experience we've had in the inner city with the City of Johannesburg, of court orders not being complied with. I raise it here purely because it was a frustration of the teams and myself in particular, and so that case we've litigated since 2015, and our clients first got an order in their favor in December 2017, and as we speak today, it's now November 2024, our clients still don't have the houses that they were supposed to be provided in terms of that court order.
And which community is that?
So it's the residents of Winnie Mandela in Ekurhuleni.
If there's nothing further that you'd add in relation to that category of judgments, the next category in 27.3 is concerned with bank repossessions and sales in execution. And there's a list of 5 matters there. Is there any comment that you would add?
I won't comment.
And then 27.4, these are examples of cases involving landlord-tenant disputes, and you've referred to some of that work and the Rental Housing Tribunal. Is there any comment that you would add in relation to those cases?
No, just to mention that in relation to the Jelle and others versus Yang Mingshan, I was personally involved up until that matter was settled between the parties in an amicable way, actually.
The next category is concerned with the PI Act and the Trespass Act, and there's a list of some 11 matters there. Would you add any comment in relation to those matters?
I think the only thing that I would just mention is that in our experience from when SERI started its work, trespass was used as a tool to avoid engaging or litigating for the eviction of unlawful occupiers through the PI Act. And so we've had clients over a long period of time who've been arrested for living in their homes. And I think even it's an issue that we are still looking at. I think very recently, as recently as 2022, there was an attempt to repeal the Trespass Act, which we felt would have been a good way forward. But the act that was meant to replace itself had challenges. But that's the only thing I would highlight there.
So, as appears from that list, most of those matters are criminal matters, state versus. So those would have been prosecutions in which SERI appeared for the accused.
Yes, except the first 2, which relate to challenges the constitutionality of the Trespass Act, both Zwane and EFF.
After that brief tour of examples of the litigation, I want to turn now to SERI's relationship with the ICF, the Inner City Federation, which you deal with at page 17 from paragraph 28, where you explain that the ICF was founded in 2015. Could you explain to the Commission the nature of SERI's relationship with the ICF, how they work together?
Thank you. So the Inner City Federation organizes residents in the inner city And a key impact of theirs has been how they support committees in managing buildings themselves. Also, another key impact of the Federation has been its engagement with the City of Johannesburg around the provision of basic services, especially in cases where there's been disconnections of services. We're also very proud of the fact that in the ICF's progression from 2015 to date, they routinely assist unrepresented litigants in the High Court in both urgent matters and other housing and services-related matters. And in our relationship, because they organize inner city residents, some of the residents they organize are also SERI clients. I think we point out in the affidavit earlier that there's, in the inner city, while we act in 37 matters, there's an additional 26 buildings that the inner city organizes in. I think in the commissioners in the inspections went to Argyle Court. And Argyle Court is one of the buildings that's organized by the ICF. And in the work that we do, when we are approached by members of the ICF in litigation, we would then approach the community together with them.
You deal in your statement with the ICF, and you've talked about building committees. Are there other similar organizations doing similar work to the ICF, and if so, has SERI worked with any of them?
So before the ICF, I think the longest standing organization that's organized inner city residents is an organization called the Inner City Resource Center. And SERI has a relationship with them, has worked with them, works with them now and has worked with them in the past. I think a notable and a good example would have been a collaboration between SERI, the ICF, the Inner City Resource Center, two organizations that are within the built environment being One-to-One Agency for Engagement and Plan Act, in engaging the City of Johannesburg on how it can support inner city residents during COVID. And we would sit in meetings with the City of Johannesburg to resolve those issues. And in fact, part of the outcomes of those engagements was the provision of interim services in some of the buildings, like chemical toilets, make sure that there's a standpipe, and so on.
We're going to turn now then to SERI's experience in representing inner city residents, which you deal with from paragraph 30 onwards. And you describe how SERI is approached for consultations by residents. And then from paragraph 31, you explain how in practice SERI would go about providing advice and assistance to those communities. Could you please explain to the Commission how that works in practice and how SERI would respond if approached by residents for assistance?
Thank you. So SERI's consultations are run by our Kenda attorneys, our Kenda legal practitioners, with the support of their supervisors. So clients would, at the onset, engage with them. And if there's a decision, so in most of the time, communities would send a representative, so either the committee or a few people that have been elected to come and speak on their behalf. And we would then arrange a meeting where we would go to that community and speak to the whole community about who we are, how we understand their instructions, what we are able to do within the law to support them. And this would normally happen. Sometimes it's the basement of the building, sometimes it's the rooftop of the building, sometimes it's a floor in the middle where there's an open space. And we'd meet with as many occupiers as are available. But then in taking forward the instruction, would then bring a large team, which would include the supervising attorney, the Kenda attorneys, and at times field workers, which we get from Wits University and other universities, and would then take instructions one-on-one from each household. And that, I think in the early days, we would have those meetings sometimes in the open spaces, but as I remember from 2013, we'd go and sit inside someone's home and take those detailed instructions. And then would come back and pull out from that information their personal circumstances, what has happened to them and their experiences. And in the meetings, I think I'd mentioned earlier that we would, if the Inner City Federation is involved, then have them in the public meeting as well. But what I want to highlight is that there isn't a case that City has acted in where they've never been inside the building. For every committee that we represent, before we took on the instruction and confirmed the instruction, we would have gone to the building. And an issue that I would have wanted to highlight later, but I can highlight it now, is that also in our work with the City of Johannesburg, where in eviction matters they are required to provide a report on the occupiers and on the building, we would attend what they call building audits with the City of Johannesburg over weekends, sometimes in the evening. And therefore, we also know that at least in every litigation matter that we've been involved in, we've been in the building, the city has been in the building.
You referred a moment ago to conducting the city audits or assisting them in the evenings or at the weekends. Why would those events take place in the evenings or at the weekend?
So it has always been to make sure that as many residents are available. And this also makes it easier for the city, because instead of then having to come back over and over again, you have maybe 3 days over a weekend on a Friday evening up to a Sunday, and you do the audit or you do it in the evening. I think our experience that many of our clients work either in precarious circumstances, so they're not able to just simply say, I'm not gonna go to work, or to those who are involved in informal work or informal trade, want to be in their trading spots at a certain time, and the visits on the weekends and on the evenings enable them to do that. Because I think, and it's something that, to be fair, again, to say the City of Johannesburg has respected and honored, and we've been doing that together for over 10 years.
From paragraph 33 on page 18, you talk further about SERI's experience representing inner city communities. You mention, as you've already explained, that SERI represents 37 communities in the inner city currently and has represented 16 of them for over a decade. And you describe how these 16 communities journeyed together with us through different phases of the city's response to unlawful occupation and provision of basic services. I'm going to take you now through the different phases of that journey, which you describe in the next part of your statement. And just to guide you and the Commission, there are two relevant sections of your statement here. There's the section that we're in at the moment, which is describing SERI's experience. And then there's the section that begins on page 43, and you may want to put a thumb there, on the development of the law and the evolution of the city's response. And in order to maintain a chronological account, I'm going to move you back and forth between those two sections, if you'll bear with me.
And maybe when it's convenient, Mr. Brickhill, we can go for tea.
It would be a convenient moment if it suits the chairperson and the commissioner.
Okay. We'll adjourn for 15 minutes. Mr. Prikil,
Chairperson, Commissioner. Ms. Zondo, you're still under oath, and we were dealing with the section of your statement headed Seri's experience in representing inner city residents. And I had indicated that we were now going to deal with the part of your statement beginning around paragraph 33 onwards that describes that experience over the years, but that in order to do so, we need to also have regard to what you say from page 43, paragraph 72, the section headed The Development of the Law and the Evolution of the City's Response to Occupiers. So if I could take you to page 43.
Yes.
Here from paragraph 72, you deal with some of the key judgments. And to be clear with you and with Chairperson and the Commissioner, I don't intend to, the judgments speak for themselves. They're a matter of law. What we want to cover here are the events behind the judgments, what was happening during these periods within your knowledge and Seri's experience. And from paragraph 73, you talk about evictions and alternative accommodation. You describe the right of access to housing as having been the most often litigated socioeconomic right in South Africa. And you mention the issues of so-called slum buildings subject to the constant risk of eviction, which you say is nowhere truer than in the inner city. And from paragraph 74, you then turn to deal with the law before the Constitution. And you've already commented on the issue of trespass earlier. In this section, you describe the common law position, the use of the re vindicatio, and the notorious Prevention of Illegal Squatting Act 52 of 1951 to remove occupiers from land. Is there anything that you would add to that set of events before the Constitution?
No.
If we move then to the next section from page 45, you introduce the Constitution and the PI Act. And again, these are predominantly matters of law. You indicate that the PI Act was passed in 1998 to give effect to Section 26 of the Constitution, the right to housing, and in 81.1 that it requires an eviction to be just and equitable. The purpose of the Act being to protect the millions of South Africans in urban areas who had no common law entitlement to the land that they lived on, at least until housing can be rolled out at scale. So you deal with those principles around the PI Act, its purpose and its potential. But it's the next section that I would like to take you to. And that deals with the Grootboom decision, Government of the Republic of South Africa versus Grootboom, and the parameters of a reasonable policy. Now, Grootboom was decided in 2001. Seri wasn't yet in existence, but it seems necessary to start the story here. So if you could just give a brief account of the significance of Grootboom at the time and what it led to, in particular your reference to the emergency housing program in paragraph 85.
Thank you. And thank you for letting me off the hook in terms of explaining Grootboom. Just to say, I think the interesting thing that we've had to explain over and over again to state officials at national, provincial, and in the city is that Grootboom was ultimately about people that are just like the inner city occupiers. It was people who were living in harsh and bad conditions, who, being faced with those conditions, had moved onto someone's lands unlawfully. They were then evicted, and after they were evicted, they became homeless. And it is those facts that bring it into the Constitutional Court. And again, it's very important to give credit where it's due. The outcome of Grootboom is the development of two housing policies in the National Housing Code, being the development of the Emergency Housing Program, which is Chapter 12 of the National Housing Code, which the minister is empowered to bring in terms of the Housing Act, and then also the upgrading of informal settlements program. And both programs are meant to address people who are living in difficult conditions. It might be in a city context, it might be in informal settlements, but it's meant to deal with people who are in desperate need. And already from the emergency housing program, in fact, one of the things that we always highlight to officials is that the emergency housing program is actually meant to respond in 3 circumstances, primarily from Grootboom and then others. And unfortunately, in implementation, it's only the others that are seen. So routinely, if you engage officials around the emergency housing program, they think of disasters like floods. Strangely, fire, which Usindiso would have been, is sometimes considered, sometimes not considered, but they always think of natural disasters when they think of how do you get the emergency housing program to come in. And the emergency housing program is brought to say local municipalities must provide support to people who find themselves in emergency housing circumstances, and they provide that support by responding to the need at that time. So it's possible that the residents of Zimbali, who are super rich, are hit by a disastrous flood, and they need to be airlifted out of Zimbali to eThekwini. That could be an intervention. But on a daily basis, the people the police is supposed to respond to, firstly, it specifically says people who are either under threat of eviction or are evicted because of Grootboom. 2, it says people who live in conditions that are at risk to their health or their safety. 3, it says people whose lives are at risk of the conditions they live in. That policy applies to. And then it's the natural disasters. And so in effect, already the policy says to a local municipality, if you end up with a challenge like this one, you don't have to use your own coffers. You can approach the provincial government for funds and use those funds to support the people who are either living in those conditions or the victims of that natural disaster. And even more specific, the EHP also provide terms of what kind of accommodation do you provide and to what end. So for instance, it's very specific that there's a standard that every unit must be a minimum of 24 square meters, that there must be access to water, that the level of the building materials that must be used, that the place must be lockable. So for instance, a tent will not meet the standards set by the emergency housing program. It also then says that you provide the emergency housing until a permanent housing solution is available. As I explained, for the residents of Zimbali, the hotels in Durban are immediately available. So once you've lifted them out of Zimbali, you put them in Durban, your responsibility as a municipality ends. But for the residents, I imagine, of Usindiso, who lost everything in a fire, what you provide for them is probably going to be long-term. After you've provided the TEA, you might then have to provide other support to them, either saying you are providing permanent housing at another location, maybe you are providing them with rental accommodation elsewhere.
So you introduced us to Grootboom 2001, explained that it led to the adoption of the emergency housing program contained in Chapter 12 of the National Housing Code. That was adopted in 2004, as you say in paragraph 85. And you then spoke to the definitional issues of an emergency, which you've set out in your statement at paragraph 87, and explaining why the sorts of situations of evictions and living in unsafe situations, unsafe circumstances, fall within the EHP. You deal with that in paragraph 87, where you quote from section 2.3.1 of the EHP, the definition of emergency housing situations. And you've highlighted 5 of those sub-paragraphs. Perhaps you could just draw attention to those and link them to the summary that you provided earlier, starting with C, live in dangerous conditions.
Thank you. So I think as I've explained, once there's a condition where the people's safety is at stake, the policy is brought in. And in example C, it specifically says, it gives an example. So it says live in dangerous conditions. So if, for instance, someone we might say it lives in a building where there's a fire risk. That is a dangerous condition. And here they give an example of where there's sinkholes and where there's dolomite. In point E, they speak about eviction or threatened with immediate eviction or from unsafe buildings. Again, it actually explains that it's not, you don't have to relocate them. You can also intervene in other ways. So you can intervene to make the building safe. You can intervene, for instance, to expropriate the land, which is actually what happened in the case that I spoke to about earlier, Marikana and Philippi, or to purchase the land. So there are interventions that the state can make, which doesn't just assume that people must leave their homes and must start somewhere else. And then the last one I think is very much connected to it, because at least in our understanding as SERI, we understand demolitions to have the effect and an impact of an eviction, but the Constitution says evicted or demolished. And in paragraph F of 2.3.1, it says if their homes are demolished or they are threatened with demolition, then there must be steps taken to forestall the consequences of that, which means to make sure people don't end up homeless.
And then if we continue over the page, and you've highlighted there H and I on page 49.
Can you read it out to me, please?
So H reads, live in conditions that pose immediate threats to life, health, and safety and require emergency assistance.
Yes, and I mean, I think for instance, a clear example, Chairperson and Commissioner, would be where there is no access to basic services. If there is no basic sanitation, there's no basic water, that's something that could fall into that subparagraph.
Conditions that pose immediate threats to life, health, and safety.
Yeah.
And then I refers to are in a situation of exceptional housing need, which constitutes an emergency that can reasonably be addressed only by resettlement or other appropriate assistance in terms of this program.
And I believe that is actually the catch-all phrase in 2.3.1. And I believe that the Commission would be able to have access to it, could be able to use that section in looking at the inner city circumstances more broadly, because it's simply a question of if it is that people need assistance to make sure that they are in the conditions that our Constitution had envisioned, then that section would apply.
Thank you. For completeness and for the reference, the EHP, the entire program, is contained in the policy bundle that has been provided by SERI. That is file 1 of the policy bundle. And the emergency housing program appears at page 327 of that bundle. It begins there with the heading, the National Housing Code, and it runs from page 327 to page 421. I'm sorry, you don't have the bundle. I'll give you a moment. Chairperson, Commissioner,
We
just
don't
wanted to
have the
confirm.
bundle as well.
It has not yet been provided to you.
Okay, no.
Chairperson, I understand it was provided to the Secretariat. I don't intend at this stage to... I understand it's on its way, Chairperson. Thank you very much. If you turn to the first page of this bundle, you'll see it is headed Index to SERI and ICF's Policy, Case Law and Legislation Bundle. And it is then...
Page number?
Chairperson, the Emergency Housing Program appears at page 327.
327.
Indeed so, Chairperson. Ms. Zondo, do you have the document?
Yes, I do.
Okay. Perhaps a suitable place to start is on page 342, which sets out the definition of emergency housing circumstances that's quoted in your statement and to which you've just been speaking.
Yes.
You see that on page 342.
Yes.
And you've commented on specific subparagraphs of paragraph 2.3.1, which defines emergency housing circumstances.
Yes.
And in your statement, you then say at paragraph 88 that the EHP applies to the city and provides a policy framework and source of funding to enable the city to respond to housing shortages and unsafe buildings. Again, I don't intend to take you through the entire policy, but you'll see that on page 343, the policy speaks to who will be assisted, and then in 2.5 at the foot of the page, funding arrangements, funding allocation by the minister, where the policy states that funding for the implementation of national housing programs is allocated to provincial governments by the minister on an annual basis. Such funds are transferred to provinces in terms of provisions of the Division of Revenue Act, and it continues to provide for the amount of the grant will be determined by the MEC based on the nature and extent of the emergency housing situation, and in 2.5.2 speaks to project funding. So do you have anything to add to your statement in terms of the availability of the EHP as a source of funding and a policy framework?
No, just to underscore that it is a municipality that must apply to access those funds to the MEC. And therefore, if there is no application, then the funds do not become available. And so it's important, I think, for us to understand that municipalities, at the very least, must apply to access the funds. And if they don't, then unfortunately, they incapacitate themselves in order to respond to these emergencies.
Perhaps just one last aspect of the policy to cover with you. On page 345, paragraph A, at the top of the page, it's headed, "What may be funded by the program?" And it reads, "Assistance to municipalities to compile project applications, land acquisition, settlement planning, basic municipal engineering services design, land surveying, basic municipal engineering services, temporary shelter or supply of materials for the construction thereof, relocation assistance, and then repair and or reconstruction of existing damaged formal housing, as well as related municipal engineering services where required." And it continues in the box, "The cost of consumption of the following basic municipal services for a maximum of 3 years in cases where the municipality presents proof of its inability to provide the services from its own resources." And the 4 bullets are water consumption, sanitation services provision, refuse removal, and street lighting where applicable, on condition that the services are actually provided by the municipality. Do you have any comment then on the scope of what may be covered by the EHP program?
Thank you. So, as I was outlining earlier, the program allows for the renovation or interventions that will ensure that that the conditions improve and there's access to basic services. And so here, as you were reading, even beyond just simply making sure the infrastructure is there, so the funds can be used to provide infrastructure, and then it even goes as far as saying all basic services, with the exception of electricity, can be funded for over 3 years from this program, which means that these funds are available for that purpose.
And in paragraph 89 of your statement, back on page 49, you say, "Unfortunately, the city has not made use of the EHP, which provides it with the framework it needs for the inner city occupation context." You've made that point. Do you have anything to add in comment on what you say in paragraph 89?
I think I'll just add a nuance, which is that in our conversations with the city, their response to us has always been, it's useless to make the application. I am aware that in this commission, in relation to the Denver TEA, they did apply for funds from this program, even though the program is now administered differently, and that they got those funds to provide the housing at Denver for the former occupiers of Remington, for a small portion of the former occupiers of Usindiso, and I think in that site as well, the former occupiers of Delvas, 1A Delvas closed, are accommodated there, and those funds came from this program.
Okay, so we've delved a little bit into the EHP, but I want to now take you back to the big picture of the events over the period of time. Just to situate ourselves, Grootboom 2001, the emergency housing program adopted 20 years ago in 2004, and you've been speaking to its current application. But if I can take you back to the earlier events and refer you to page 51, paragraph 95 of your statement. In fact, more helpful to start page 50, paragraph 94.
Yes.
Here you talk about the city using the National Building Regulations and Standards Act 103 of 1977 to characterize some buildings in the inner city as health and safety concerns, and seeking to remove occupiers from those buildings on the basis of health and safety. And in paragraph 90, from paragraph 95, you speak to events from 2002 to 2006, where you say that approximately 10,000 people were evicted by the city under the auspices of this strategy. And in paragraph 96, go on to refer to the Constitutional Court's judgment in Olivia Road. If you could just describe those events briefly, the use of this National Building Regulations Act, evictions on the basis of health and safety, and then ultimately the Olivia Road decision.
Sure. So the commission last week had Mr. Ketani give evidence, and he was actually one of the people whose community was evicted in terms of this and at this time. Their application started around this time. And as I explained in the affidavit, over 10,000 people are displaced. At that time, the city is evicting people using these notices, and is not providing alternative accommodation, is not engaging them. It's simply closing down these buildings. And it is when the occupiers of Olivia Road get a court application and they approach CALS, and CALS assists them, that we have the city's policy, which is simply that, look, as the city, we are trying to respond to the conditions in these buildings, and in order to keep people safe, we are evicting them. And the consequences of that are not for us to address, right? Therefore, the residents must house themselves, must sort out their own housing crisis. And it is already in the High Court, as Mr. Ketari actually explained last week beautifully, that the High Court said, but that's not something that you can do. And when this matter goes before the Constitutional Court, of course, there's a different focus being on how the city should have engaged with the residents. And the reason why the Olivia Road case becomes the precedent on meaningful engagement about how the city and how the state should engage with unlawful occupiers. And I know because in our work on a daily basis, Chairperson and Commissioner, we speak about how it is important to not forget the relationship and the conditions that bring people to the bargaining table. And I'm paraphrasing it here, but in the Constitutional Court makes it clear that when the city approaches residents, even if they meet a recalcitrance, they must understand the conditions the residents find themselves in, and they must attempt to engage the residents in a way where they find collective solutions. And ultimately, of course, there is a settlement, as Mr. Ketani explains. They are moved to MBV phase 1 as the residents. But for us, we develop a principle that was already in any event at the time part of our housing code, that you must meaningfully engage the communities that you work with. Even if you are developing housing solutions for them, it's not simply for you to throw housing solutions for them. You must engage them as citizens, as stakeholders with you as the state. And that's where we end up there, through the experience of many inner city residents. My belief, and I think it's borne out by experience, is that those 10,000 evictions, for every building that had bad conditions and people were evicted without alternative accommodation, it simply transferred the problem to another building. And what you then had is overcrowding of what was previously a healthy building. Because ultimately, if people are told you can't stay here, then they must find a place for themselves to stay. Of course, worst of worst, they can be under a bridge, they can be on the street, but also if they're able to, they'll go and negotiate where their cousin stays, where their friend stays, where their colleague stays, where it's available. And that itself impacts the slum-like conditions. So the problem doesn't end, it's just transferred elsewhere.
So you've talked about those evictions happening during 2002 to 2006, and then Olivia Road is decided in 2008, ultimately in the Constitutional Court. In paragraph 97 of your statement, you then refer to two later cases of the Constitutional Court, decisions of the Constitutional Court, in Peko and Schubert Park, which you summarize in paragraph 97, these related to evacuations from homes on the basis of health and safety, and you summarize in 97.1 to 97.3 the state's obligation, even in the instance of such an evacuation, to provide alternative accommodation. So we have Olivia Road, and then Peko and Schubert Park in 2010, 2011 and 2012. And then if I take you to paragraph 98 of your statement, you speak to what you understand to be the effect of the Olivia Road judgment on what was then happening in the city of Johannesburg. And you say that the requirements relating to engagement in Olivia Road, together with the decisions in Peko and Schubert Park on obligations in the case of an eviction, in your language, effectively put a halt to the city's strategy of forced removals from occupied buildings on the basis of health and safety. And you say the city did not have the political will to start providing shelter to the inner city poor at a large scale. Could you explain your view there on what was happening following those three decisions?
So the outcome, I think, probably the outcome of Olivia Road, that the city understands that they have an obligation to provide alternative accommodation for everyone they remove, which means that for every removal, they must know where people are going to go, number one. But number two, what Peko and Schubert bring in is a further complication, because both Peko and Schubert Park say, if you evacuate someone, in Schubert Park it was a fire, in Peko it was dolomitic conditions, from their home, that evacuation is only temporary. So you evacuate them, but you have an obligation to bring them back to their home, because you don't have an eviction order, a permanent eviction order against them. And what then that means that for the city, they say, we've dealt with Olivia Road, for instance. We've removed the occupiers of Olivia Road. But then what they must do, they must go and put them in temporary emergency accommodation at Denver, let's say, or let's say MPV phase 2, because that's what happened, MPV phase 1. And then they have an obligation to bring them back to Olivia Road after the conditions have been improved. And that triangle, I imagine the city worked out, doesn't work for them. But I believe that another intervention would have been better. Would have been if the city's position is, we actually, one, it's going to be more costly for us or more difficult for us, then we don't have to intervene and take people out of a building and then to another place and then back to that building. But we could simply intervene in that building. So I think in this commission we've been, Mark was here earlier last week, and he says, for him, one of the safety issues is whether people are able to escape during a fire. Then your focus should be on making sure that access and egress in those buildings is rectified. If the issue is lack of access to basic services, you address that, and I'm sure we're going to get to the point we speak about how indigent and poor households can access that in a way that the city is supported. And I feel like that could have been a possibility, but at that time, the city just simply said, they simply folded their arms. They were like, okay, forget us, forget this, we are walking away.
And you say then in paragraph 99 of your statement, consequently, the burden of removing the poor from the inner city passed from the city to individual private owners.
Precisely, and I think part of that is that also in the time, the city would then also use the powers they have in terms of the NHBRC to say the owner must resolve this. And it's difficult because we didn't go into the history, but we know there was a mass abandonment of inner city buildings from the early 90s to the early 2000s. So even those owners were absent. But there were ways in which that manifested itself. One, at the level of, which I'll speak to more later, a little bit later, of getting investors to come in who buy these buildings for next to nothing. And then they are then told, you must get the occupiers out. It's your problem to get the occupiers out, you get the building. But there was never a point where people said, what will happen to the occupiers? Where will the occupiers go?
So that takes us back to the trajectory of the events. And if I could take you then back to page 18 of your statement, please, in paragraph 34. And just to situate you again, we're back in the section of your statement that deals with Seri's experience representing inner city communities. And we've moved from Grootboom in 2000, the EHP in 2004, Olivia Road, Pekwa and Schubert Park, taken us up to about 2010, 2011. And we're back at that point in time, where in paragraph 34, you describe how the city would provide dormitory-styled accommodation to people who had been removed from their homes. And you provide some examples there. And you describe the city of Johannesburg's stance in 34.2 that it had no role to play in cases where eviction orders were sought by private property owners, even if the evictees were at risk of homelessness. So you've described that burden had shifted to private owners who were buying up properties as investments on the basis that they would then evict the occupiers. And the city's attitude at that time was that it had no obligation in those circumstances where an eviction was brought by a private owner. And in paragraph 35, you then describe the Blue Moonlight judgment. So if we could pick up there, and if you could just describe what was then going on at this time, and again, without going into too much of the detail of Blue Moonlight, what it decided and what its effect was.
Sure. So I think the first thing is that the wave of evictions that we were dealing with at the time, as I explained, were due to the development of the Gautrain. There were buildings that were relocated to make way for the Gautrain. Again, last week, we had someone who spoke about the Moth building, which was provided to some of those residents. Some of them were evicted out of historic buildings, like Chancellor House, where President Mandela used to practice, and those residents were then moved to the Moth building. And when they were moved to the Moth building, they were simply put in a hall and they were just given beds. And people wanted privacy. And so what then happened is that people put curtains to provide that privacy for themselves. Again, even that had been an outcome of litigation, but because of the way that the accommodation had been provided, the conditions worsened very, very quickly in those buildings, both in terms of the access to basic services, to the conditions inside. And then at that time, property owners were now interested in the inner city as a place for economic opportunity. And eviction applications were being brought. And again, property owners were saying, I just simply want my building back. In a very simple, I want my building back. I don't know who these people are. Or I know I bought the building last year for 50,000 Rand. I found them here, but I want my building back. And in that process, the city's stance was very clearly we don't have an obligation. You are the one who's evicting. You must then, actually, it has nothing to do with us. Between you, the occupiers and you sort yourselves out. And in that process, we have Blue Moonlight, which starts actually, interestingly, if I may say the anecdote, Chairperson, when they consult at the Vets Law Clinic, I was a candidate attorney, and I consulted the residents of number 7 Saratoga. And I then told them that at the Vets Law Clinic we wouldn't be able to assist them. They must go and speak to Carls. I know this because when they then found me at SERI, they were like, how? Do you remember that you're the first legal person that we consulted with this problem? And when they go to Carls, again, the point is that there is an obligation for them to be provided with accommodation. It's fought all the way to the Constitutional Court. And the city's position, and it's amazing because it's a position that even today municipalities take, is that housing is a provincial and national competence. It shouldn't be for them. Those two spheres of government should deal with it. And they also say we don't have the money. And the Constitutional Court clearly says, but before you don't have the money, did you budget? Can you show us how you've budgeted to do this? And then they have the obligation. At that time, in the courts, so Mr. Famak was still acting for the city at that time, there were numerous eviction applications that were waiting for the Blue Moonlight judgment. Mam Jabulile Ndebele was also here last week. Her building, in their eviction application was being pended to wait for Blue Moonlight. Then when Blue Moonlight came, the next problem was what kind of accommodation must be provided.
And you've described some of the dormitory-style accommodation that was being provided. In paragraph 37 of your statement, you refer to Ekutuleni shelter and the challenge that followed in the Dladla decision. So could you perhaps pick up there? What was the dispute there, and what was the city doing at that time?
So I mentioned that SERI was involved in enforcing the judgment, the Constitutional Court judgment at the time, because the city actually didn't provide the accommodation. There was litigation, but then in the end...
Following Blue Moonlight.
Following Blue Moonlight. But in the end, the city separates the residents into two groups. A group that can afford to pay 600 Rand, and the group that can't afford to pay 600 Rand. And the group that could afford to pay 600 Rand were given accommodation that was at the time managed by the Johannesburg Social Housing Company, Joshco. And the second group went to the Ekutuleni shelter. But at the Ekutuleni shelter, there were rules. And the first thing about the rules was that they were told that they would be there for 6 months. They moved in, I believe it was in May of 2012. They were told that they can be in the shelter from 5 in the evening and 8 the next morning. That they would be in gender-segregated dormitories. So if you had children, male children would go with their fathers, female children would go with their mothers. And then also, if you were in the shelter, outside of the shelter after 10 o'clock in the evening, you would not be allowed back in. So there was a cut-off to come into the shelter. And that is the litigation that I participated in, having taken over from Mr. Mngomezulu, who was the initial attorney of record. And initially in the High Court, there was a settlement, at least to make the conditions less harsh, especially in relation to people having access to the shelter during the day. And then ultimately, the High Court found that the rules were unconstitutional. And then it went to the Supreme Court of Appeal, who actually found in favor of the city that the rules were constitutional. And then eventually, when you got to the Constitutional Court, it was a relief that the court could see that the dignity of inner city residents require at the very least that they're able to live with their families. That at the very least, if your child has a toothache, if you are feeling unwell, you should be able to go to bed in the place where you live. I'm saying this again with the anecdotes. I apologize, Commissioner Mabena and Chairperson. In the office, we had a, what do they call it? A pact that if we lose this case, we'll stop practicing law and we'll go and farm somewhere. Because we felt that at the very core, at the very least, our constitution demanded that much. And so we were quite relieved that we didn't have to abandon law when we succeeded before the Constitutional Court. And we had hopes that after that, the city would have, because in the process.
If I can pause you there and I'll take.
So
just to confirm that you, in paragraph 42 on page 21, you describe the outcome of the Dladla decision, in which the Constitutional Court confirmed that the two rules you've described, the daytime lockout and gender segregation, were unconstitutional. And you say this removed any doubt regarding the standard required for TEA in Johannesburg. But if I can take you back, because you're saying in the meantime, to paragraph 39 of your statement at page 20, where you say, while Dladla was still being litigated, the city brought an application to pend 29 eviction applications, which you describe pending the final determination of Dladla, which you describe as the stay application. What was this stay application about, and what was happening at this time?
So the position, so the city brought this, it was actually brought as an ex parte application in 29 evictions, and what they were asking for the court was that they wanted their obligation to provide accommodation to be frozen until there is clarity on what type of accommodation they could provide. At the time, we represented buildings, occupiers in 10 buildings.
As you say in paragraph 40.
As I say in paragraph 40. For instance, one of the buildings, also a building that's been mentioned here, being Remington Court. So at that time, Remington Court was before the Pretoria High Court for an eviction of the occupiers there. And the city then brought this application. We, at the time, brought a counter application asking for the court to order the city to show us their plan and their budgeting to execute this later on. At the time, the city's response was simply to say, this is above our means, and we need the province and the national department to support us in rolling this out. And they joined them, and that joined application, I believe, was granted. And then I think soon at that time, then the judgment in Dladla came out, which then made their application unnecessary because there was now clarity. It was clear they had to provide the accommodation in terms that respected people's dignity.
So as you say in paragraph 42, the stay application of these 29 evictions was never heard, even though papers had been filed. And then Dladla was decided, which you say clarified the city's obligations.
Indeed.
If I can then move you forward to page 22 and paragraph 44 of your statement. We're now at the point in December 2017 where the Dladla judgment has been delivered. And you say there was much uncertainty with the city advising courts that it did not have temporary emergency accommodation and would not have it for a period of 2 to 3 years. And you say this was characterized by various things. Could you explain then what was happening from that point in late 2017 after Dladla?
So at this time, the response that the city was providing was to tell the court in eviction matters, where they'd file a report, that they do not currently have the accommodation and will not have it for 2 to 3 years. So they were not even able to give a court a definite date of saying, we'll have it in a year's time by this point, so that it was making it difficult for property owners even to give them that time. I think one of the things that had happened in the process from Blue Moonlight onwards is that property owners accepted that they must wait. They must wait for the state to provide the alternative accommodation. But now we sit post-Dladla, there's clarity on the terms of the accommodation, And therefore, property owners who have been waiting, some from 2007, some from 2011, are expecting that at this time, they'll be first in the line, the accommodation will be provided, and the city's response is simply, we can't do it. And what property owners had to do, and in fact, Mr. Vermaak was involved in the two cases that I mentioned in paragraph 44. What the property owners had to do is then litigate to the end, fight it out to the bitter end, have a court order the city to provide the accommodation. And in relation to the two buildings that I mentioned there, which is Ingelosi House, which I just mentioned earlier, at 8 O'Reilly Street, and Kiribili, the court says that regardless of what the city says, it's going to order the provision of accommodation, and there's some latitude given to the city because they are given until the 30th of October 2018 to house the occupiers of Ingelosi House, and then the 31st of July 2019 to house the Kiribili occupiers. And those dates came, and there was nothing. The dates came to the extent that SERI and the property owners, they actually brought an application together to enforce compliance with the court orders. And even then, as I explained, it was only when there was a fire at Ingelosi House that the accommodation was provided. And in Kiribili, it was only when the city was sued for damages by the owner of Kiribili that the accommodation was provided in March 2021. So March 2021 would be almost 2 years from the date the court had ordered.
Thank you. So you continue in paragraph 45 to talk about events since 2021, where you say the city has only responded to evictions of smaller communities, allocating them to available rooms and spaces in existing temporary emergency facilities. The city's approach to requests and applications for reconnection of services has been to mostly oppose such applications. But, let's limit ourselves to TEA at this point. And if I could take you to page 39, paragraph 65 of your statement.
I'm there.
Here you're describing the different policies, and you've just dealt with the temporary emergency accommodation housing policy of the City of Johannesburg from paragraph 64. What I'm concerned with for the moment is the implementation and what you say at paragraph 65. You say, despite the above policies, or perhaps because of them, the city has not been proactive in the provision of alternative accommodation to occupiers in the context of eviction proceedings. In this regard, of the 10 accommodation alternatives delivered by the city, 9 were as a result of court orders. You made that point earlier in your testimony. And you continue, the city has yet to embrace its obligations in a proactive manner. Further, the accommodation has been poorly managed, creating the potential for an informal local market in rooms for rent and security concerns for tenants. So if I can just situate you again, big picture, we are post-Gladla, which has clarified the city's obligations in terms of what type of alternative accommodation needs to be provided. And you're here commenting on what is in fact being done and the existing facilities. Would you comment on what you've said in paragraph 65 and whether there's anything you have to add to what you've described there about the current state of TEA?
So as I've explained, even today, there are matters where court orders have ordered the city to provide alternative accommodation. Those dates have gone past, and the accommodation has not been provided. So it's not even a matter, so it's not even a complaint of only the city not being proactive. They're also not being reactive. In fact, the only way in the past while, even dating back to before Dladla was finalized, the only way to get accommodation provided is to then go on to bring contempt applications against city officials. And when there's a risk of them being held in contempt, may be made to pay a fine personally, or even being at the risk of detention, that things start to move. And again, another example the Commission has heard about is Remington. And in Remington, it had gotten to a point where even the contempt application could not move because the city officials or the office bearers had changed. But at that time, it was only because the court had gotten to a point where it said, actually, it's fine. I'm happy now. I'm simply going to move forward and hold these officials accountable. It was only at that time that when it was clear, not only that the city manager, the mayor was on the hook, Mr. Poppy was on the hook, Ms. Malusi, who was the director for the urban core at that time, was also on the hook. Otherwise, without that, no action from the city. So not only I feel like I've put it too courteously, as Mr. Mahlang would say, in that point there. I've put it too courteously by saying they've not been proactive. They haven't even been reactive. Because if they were being reactive, we would know that those court orders would have been met at the time they were meant to have been complied with.
So we're now fairly close to the current period, and there's one more set of events that you describe from paragraph 46 on page 23 of your statement, where you talk about raids carried out in the inner city since 2021. And you say that they've been accompanied by the disconnection of services, and you speak to one instance at Industry House on or around 3 March 2022, when the raid carried out by the city and its entities under the leadership of former mayor of the city, Mpho Palatse, resulted in them disconnecting a standpipe which was initially provided by the city on the basis that there was no water in the building. But I wanted to ask you to speak to this issue of raids more broadly now, and if I could take you to where you deal with the litigation on this issue at page 57 of your statement from paragraph 104. And there you describe in paragraph 104 that SERI represented the residents of 11 buildings in the inner city who were challenging the lawfulness and constitutionality of over 20 police raids conducted at the behest of the Minister of Police and the Mayor of the city, then Herman Mashaba, between 30 June 2017 and 3 May 2018. Could you then speak to this issue of raids and the particular litigation described from paragraph 104 and into 105, which ultimately culminates in the judgment in Residence of Industry House, 5 Davies Street?
So just to say, I think raids have been a tool that the city has used over time. So I have a distinct recollection of missing a call at 4 a.m. in December 2015 because the Changwa occupiers had the Metro Police come and told them the owner wants his building back. And they drained the whole building and locked people out, and we had to bring an urgent to have them reoccupy their homes. At that time, as I explained earlier, those occupiers had been waiting for 3 years for the city to relocate them. But the city could send a raid to that building and evict the people unlawfully. But the circumstances that you speak to from 30 June 2017 to May 2018, it is a time when an operation was started by Mayor Mashaba. In fact, when we brought the litigation chairperson, we attached press statements or press releases that came from the office of the mayor. So after each raid, there would be a press release from the mayor to say, we have done this, we have gone to this building, and this is what we have done. And our client's experience was that firstly, they were threatened violently. One of the, again, that last date of the 3rd of May, we had been, in that case, we act for 2,811 occupiers. We had been preparing the case as of the 3rd of May, but we were not yet done. But on the 3rd of May, there was a raid at 2 a.m. The 3rd of May of 2018 was on record as the coldest day of that year. And at 2 a.m., the police came and they drained people out of Industry House. They, some of them were still in their night dresses. Some of them, someone even jumped, trying to run away. Because at 2 a.m., again, there's an expectation that you are safe in your own home. And when that last raid happened on the 3rd of May, we were like, whatever loose ends that we have not tied, we must tie them now. We must start the litigation as instructed by our clients. And in the process, what was clear to us and clear to our clients, and in fact, the High Court finds this, that these raids were meant to intimidate occupiers, to make life so unbearable in the inner city or in the buildings that they are in, that they find somewhere else. Go scuttle under a bridge, go I don't know where. And it was also interesting for us that in the buildings that we acted for, all of them in those buildings, the city knew us, they knew the buildings, they'd been to multiple building audits in those buildings. So there wasn't actually a need for them to raid because they had direct access that we had even facilitated. But they had JMPD, they had the police in those buildings, sometimes at inhumane hours, like what happened on the 3rd of May. And they had been using a section in the Police Act, Kanane said I mustn't go into the cases, in the Police Services Act, which allowed them to cordon and search.
You speak to that in paragraph 105 and 105.1 and 105.2, section 13, subsection 7, paragraph C of the South African Police Service Act, which you explain was ultimately declared constitutionally invalid.
Yes, and at the very least, after the judgment, there was some silence. But as you point out, the incident with Mayor Palatse was now a new mayor who was thinking to use the very same tool. So every new mayor, for some reason, there's a mental block, there's a lack of creativity, because every new mayor, every new politician who comes, they go back to the same old toolbox. So Mayor Palatse now comes, having taken over from Mayor Mashaba, and she's using the very same tools. And we remember on the day, again, I was personally involved because at the time I was the attorney of record for Industry House. We wrote to the mayor and we said, but the mayor is a doctor. He's cutting off water that is in a tap outside in a building that houses hundreds of people. And how is that lawful? And again, to be fair, the response that we got from the city was to immediately reinstate the standpipe. But those raids did not just happen in Seri, in communities where Seri or the inner city operation is active. They also happen in other communities. And I'm raising this point because also those raids were also about disconnecting existing services, disconnecting water, disconnecting electricity. So almost zapping the buildings of oxygen, making sure that the conditions deteriorate even further. And that's why the raids have really been a very draconian tool that has really oppressed inner city occupiers and have also made the conditions worse.
These were police raids. Has Seri represented, have there been criminal prosecutions that flowed from these raids, and has Seri represented occupiers facing criminal prosecution arising out of them?
No, we have not, but the one thing that was so in the course, in some of the buildings, people are arrested for being undocumented migrants. But unfortunately, as we know the country that we live in, before people even got to the police station, they had to, if you gave 500 rand, 200 rand, you went back to the building. In terms of criminal prosecutions, we were not involved in any, we did not learn of any. But for us, even in the case itself, what we raised was the fact that every time the police applied for these warrants, because the warrants are issued by the provincial commissioner, they would use the same statistics, or the statistics would not have improved. And the question for us was then, how useful is this tool? You go and terrorize people in their homes with information that is not about that specific building. And then you go back, and then a month later, you are back in the same building, doing the same thing. Why should this happen? And the reality is, there was no impact on either side. At least I would have expected on the positive side that the information that the city, which it had all along, got out of these raids, would have then been used to make the conditions better, would have then been used to proactively plan for alternative accommodation, could have been used to plan for the upgrading of these buildings, but it wasn't.
If I can then take you back to your statement, and this is where you conclude this account of the events in paragraph 47, where you speak to the city's awareness of conditions in many of the buildings, as well as of the identities of the people who live in those buildings. You comment that it's likely that the city has visited many of the buildings in relation to eviction proceedings, that it's aware of the living conditions of the residents and may even have granular details about the identity of the occupiers, including their various details. Would you comment on what you say there about the city's knowledge of conditions in the buildings?
So in all the matters where there is litigation, especially for evictions, one, as I explained earlier, we've engaged with the city to conduct building audits. Those building audits, the city officials go with us inside people's homes. So there isn't even the rest that it's other people who've come from outside who are claiming to live here. And in the course of that work, the city also insisted that every time the status of the individuals must be confirmed by Home Affairs. So people would have to go to the Department of Home Affairs, put their fingerprint in the fingerprint machine, and then they come out with a single page, an A4 page, that would confirm their status, mostly as South Africans. So, and as an example, for instance, again, I can go back to Remington. In preparing for the relocation of the Remington occupiers, the city of Johannesburg had a profile of who lived in the building, their income, who's documented, who's not undocumented. And I remember, for instance, that it was only 7 people who were undocumented in the pool that they had that had been audited. So the level of detail available to the city could start data on who lives in the inner city, what are their circumstances. If we're talking about unaffordability, what is their affordability? That information is currently, today, in the grasp of the city.
Thank you. We're going to move now onto a different set of issues. The next section of your statement, which I don't intend to cover with you in any detail, is the section dealing with the city's housing policies. You've indicated at the start of your testimony that aspect of the statement relied significantly on Ms. Royston's knowledge and expertise, and we will in due course lead her on those policies. But in this section from page 23, you trace the development of those policies from actually the early 90s, the spatial and economic framework, the bad buildings program from 1999 to 2007, the inner city transitional housing policy from 1996, the transitional housing program from the early 1990s, the Johannesburg 2030 master plan developed in 2002, on to the inner city regeneration strategy in 2003, to the urban development zone tax incentive, UDZ, also in 2003. Moving on to the inner city housing action plan, ICHAP, which came later in the 2000s. The inner city property scheme in 2007, ICPS on page 33. And then which was revised into the Better Buildings program in 2001. Moving on page 34 to the Inner City Transformation Roadmap of 2013, the roadmap. And then a set of bylaws, the Problem Properties Bylaw, which have already been addressed by this Commission in argument in Part 1, and were addressed in the Commission's report. On page 36, you deal with ICHIP, the Inner City Housing Implementation Plan of 2014, which in due course will also be the central subject of Dr. Tanya Zach's testimony later this week. We move forward on page 37 to the Inclusionary Housing Policy, IHP. And then over the page 38, this policy is the Temporary Emergency Accommodation Policy, and you've already spoken to that policy, and you talk to its implementation in paragraph 65. and the failure to implement the TEA policy. So don't intend to take you into the content of any of those policies in detail, but from paragraph 67, you, supported by the confirmatory affidavit of Ms. Royston, draw 4 conclusions about this policy story over that period of approximately 30 years. And there are 4 big picture points that you make in your statement. And I'm going to ask you to speak to the first 3 of those concluding remarks. The 4th relates to ICHIP, and we'll deal with that with other witnesses. But the first, on page 40, paragraph 68, is a conclusion about a consistent problem with implementation. And you speak to that in the sub-paragraphs. The city's awareness of the inner city housing crisis, 68.1. Initially, the city being ignorant of its constitutional obligations, and you've spoken about Blue Moonlight and Gladla in particular, and Olivia Road clarifying those obligations. And then from 68.3, you talk about how the city has been largely unsuccessful in the implementation of its policies. And you say we need to better understand the problems with implementation, and that a review of secondary literature shows that implementation problems may relate to certain factors. And you mentioned 3, and I'd ask you then to speak to those factors and add any comment that you would wish to add to paragraph 68.
Yeah, so I think primarily in relation to the inconsistent implementation, here we're speaking about the more progressive of the city's policies. That those more progressive policies, in fact, including even some documents from province, have been ignored, primarily because there's no political will, or at least politically, the position is that the poor shouldn't be in the inner city. Mr. Vermaak, I think when he came to give evidence, he spoke about white dunes outside the city that would be better for the poor. And I feel like that position is one that's shared by the political leadership of the city through the time. Not even necessarily, you can't even say Mayor Parks Tower was better, Mayor Masondo was better, Mayor Mashaba was better, but consistently the position has kind of been the inner city is not for the poor. And therefore that's hampered, it's made it almost like there's been an unwillingness to provide the housing, even with court orders, even with policies that are very clear. In fact, in the city's special development framework, there's this understanding that there must be housing for the poor in the inner city. It's there. There's a commitment there. But that commitment, when it meets the political leadership, when it meets the officials, completely disappears. There is, I think, one of the things that maybe we'll speak to later, I don't know if I'm jumping the gun a little bit, is a failure to support the city. Because I do think that the complaint that there should be support coming from the province and national is a valid complaint, is a valid concern. And in fact, it's a legislative mandate of both the province and national to support the city in implementing the housing policies. And so if they've been failing and failing consistently, that should have been done. They should have gotten that support even before they called for it. I feel like the stay application was their attempt to cry out for it in a very clear way. But even before they called for it, they should have gotten that support, number one. Number two, I do think that the fixation, this thing I said about the toolbox, the very limited toolbox, which is 68.3.3, with private-public partnerships. The private sector has spoken loud and clear to say the affordability of where most of the people that are in the upper part of the auditorium is not a field that they will play in. Even the social housing institutions say clearly that this group of people they cannot provide housing for. And we've called consistently to say then that's the place for the state. And so to simply say no, partnerships won't work.
Can I ask you to clarify which people you're talking about, that the private sector can't cater for and that social housing also doesn't?
So maybe
provide
just to step on Lauren's toes a little bit, in Minding the Gap, we identify that half of the inner city, as at the time we issued the report,
In
was in
2013.
2013, according to the census, was earning below 3,200 rand. And on the housing affordability index, they should not have to commit more than 30% of their income to rental. But in fact, what is proper is not more than 25%. In fact, all of us should not have to commit more than 25%. And I think the poorer you are, the more that principle must be protected. Because then if you spend more on your housing, then you won't eat. Your children won't be educated. And there's other consequences that impede on constitutional rights. And that group of people, if they can only pay 800 rand a month, both the private sector and the social housing institutions say that that's not affordable. They say they will not be able to break even at that level of intervention. And therefore, that is a place where only the state can intervene. And the sooner that is accepted, the more we can move towards progress.
I think this links to this, the reason you give as the second reason for problems with implementation from page 41, paragraph 69, where you say in paragraph 69, second, the concept of regeneration, as well as the manner in which the city seeks to partner with the private sector, fails to cater for poor residents. And you explain that in the sub-paragraphs. Do you have any comment to add in relation to this concept of regeneration and the city's approach to regeneration?
I think the earlier point covers it. But just to say that, for instance, in relation to the inclusionary housing policy, there was an obligation put on the private sector to provide a part, I think 20% of the units, to that lower market. But again, it's for the city to enforce that, and we have not seen it.
The third reason that you identify is on page 42, paragraph 70, where you say the policies and programs of the city do not account for the people who currently reside in the occupied buildings. You go on to explain that the city has maintained a central focus on buildings, with the program names changing from bad buildings to better buildings and then to problem properties, rather than focusing on the occupiers who live in them, their needs, rights, and capacity to afford rental and services. And you then add a comment about hijacked buildings. Could you speak to that third reason of a focus, a lack of focus on the people who live in the buildings?
So for me, that is, Chairperson and Commissioner Mabena, that is actually the place where we and the city lose each other. And I'm saying we here in a way that is maybe too loose, because I'm also speaking on behalf of the clients that we represent. That the focus for the city is the buildings. And I believe that, I know for a fact, that the clients that we represent want to live in buildings that are in the best possible conditions. They don't want to live in the conditions, even the ones that are better that they are in. So there's agreement there. There's agreement that the inner city, as the lounge of Johannesburg, must look a certain way, must be looked after. That's also agreed. But where we lose each other is what happens to the people who are living in the city now. For, even though from Blue Moonlight, even from Olivia Road, there's been close to 2 decades, that's the amount of time that has passed, the position of the city has remained that those people, the occupiers of the inner city, including whether they are lawfully in the inner city or unlawfully in the inner city, should not be their problem. And we believe that if in their planning they'd calculated, budgeted, made a plan for those people, then progress would have been made. So that we don't fix this side and the fire comes this side. We don't remove people this side and the problem becomes worse this side. When we are focusing on this side, then the problem comes back to this side. We believe that if the plan from the onset foresees accounts for the people who live in these buildings, whether lawfully occupied or unlawfully occupied, and makes a plan to include them in the inner city. And I'm going to bring Mr. Femak in here because we have had a lot of conversations around the issue of the inner city and the specific aspect that he says about the inner city is for rate-paying people, it's for these type of people. And the conversation that we have and the belief that we have, firstly, as an organization, and I believe it's a belief that the Inner City Federation holds. I believe that it's a belief that the residents that we represent and that the Inner City Federation organizers hold, is that there must be a place for the poor in the inner city. And so if you're going to plan for the buildings, alongside that plan for the people, and plan for the people to be accommodated in the inner city. And I say that knowing that there are many people who oppose that view, and there are people who oppose that view with justified reasons. Maybe they've gone through a thought process. But for us, it's also very much a part of acknowledging the country that we live in, the circumstances we find ourselves in today. I'm not talking about we find them in 1994 or in 1992, today. My team knows, I'm sure now they're going to laugh in the office if they're watching on the screen. They know that without fail, I always mention the land audit report that Delrat did in 2017. And it tells us that when it comes to ownership of property, if we're only looking at land size, the African population only holds 4%, if we're only looking at land size. If we're looking at numbers, again, there's at least more numbers of black people, especially in urban areas, who own. But that's still only a third of the population. 2/3 of the population live outside the property, the deeds registration system. The deeds registration doesn't know them, will never engage them. And if that reality persists today in 2024, it is only the responsibility of the South African government to fulfill the Constitution by making sure that people who today don't have access to land are able to access it. And it's there to facilitate it. Again, the issue of choice. Because, as I explained, in 1980, in fact, in 1992, Umamu Esther Manamela, who was the oldest resident of Remington Court when I consulted with them in 2013 to take their instructions, she started living at Remington Court, paying the landlord money under the table, and would hide herself, having made that choice because of the time that we're in. I really, really feel like at this point in time, it's important that with this kind of background that I've given, this context, that there must be an accommodation, I'll put it in that way, an accommodation for poor people who want to live in the inner city.
There's one more related topic to which I would now ask us to turn, and that's the question of basic services. And you've spoken to it in passing at certain points, but your focus until now has been on housing and alternative accommodation. You deal with basic services obligations from page 58 of your statement, and it continues up to page 75. Now, you provide a detailed account there of the legal provisions, starting with the constitutional rights to water, electricity, sanitation, as they've been given effect to in legislation and ultimately by policies of the city, among other municipalities. And it's at that point that I would like to pick up, if I may. If I could take you to page 74. And again, I don't want to focus on the content of the law, that will be a matter for argument. But on page 74, having discussed some of the city's bylaws around electricity and credit control, in paragraph 150, you explained that in 2008, the city introduced the expanded social package, the ESP, giving qualifying citizens in the city access to free basic services. And in paragraph 151, you explain what the ESP is intended to do, what it is. And in paragraph 152, you speak to your experience of its implementation in relation to SERI clients. If I could just ask you then to begin in paragraph 151 and explain what the ESP is, and then speak to your experience of its implementation in relation to inner city clients.
So the expanded social package, Chairperson Commissioner, is the city's way of providing support to indigent households. And so it goes beyond in terms of the provision. It provides for basic services like the 6 kiloliters of water, the 50 kilowatts of electricity, but it even provides support like transport allowance to be able to use the metro bus and so on. And you have to apply every 6 months to show that you are indigent and require this support. And then at the end of the 6 months, it is renewed. And the challenge that our clients have experienced, that even those who are aware of the ESP, and the Inner City Federation could speak much more fully on this, even those who are aware of the ESP who register on the ESP, so are able to say, we qualify to get this assistance, are not provided that assistance purely on the basis that there are too many of them. Initially, in the past, the issue that used to be raised was that they need the utility account number for the building. But most of the occupiers, most residents, would know what's the account number for the building they live in. So if the city's system could pick up that here is COJ 553-2025 and say in that utility account, there are 100 poor households, therefore we'll add 50 kilowatts times 100, it would work out. And in fact, I'm reminded that there was a point when one of the officials who was in the revenue department had said, this is what we can do, this is what we should do, is be able to say, if we know that these are the number of households, 200 of them, we provide the benefit to the building and to the account. This is important because from the city's perspective, firstly, in terms of, I'm not gonna go there. Mr. Bricker, I don't want to trip myself up.
Perhaps then we can just take you back to your statement where in paragraph 152 you conclude, however, there are major failings in implementing the ESP, and many people who qualify do not receive free basic services from the city. In practice, residents are not assisted by the city to register under the ESP, and even if registered, are not provided with the free and/or subsidized services that it guarantees. Do you have anything to add to your conclusion there?
That is accurate.
Yes, may I just make inquiries? What is the meaning of FBS?
Free basic services, I apologize, Chairperson. Free basic services.
Chairperson, it's defined a little bit earlier in the statement. Ms. Sondo, the next part of your statement deals with the data sets and research on housing affordability, quality of life, the issue of the unique experience of women in the inner city. And you've explained at the outset that those issues derive from SERI's research. They're primarily within the expertise of Ms. Royston. I don't intend to cover them with you. I will then take you to the end of your statement, where you set out proposed findings and recommendations. And of course, the Commission has not yet concluded. More evidence is being heard. There will be argument. So in a sense, these would be provisional at this stage. But I want you to speak briefly to your the proposed findings and the proposed recommendations that you set out. So if we can go to page 133. On this page, you set out 5 core findings that you propose ought to be made in part 2. The first, in paragraph 281, is that the city's policies in their formulation and/or implementation have been insufficient to address the issue of abandoned and occupied buildings, and that this is a contributory factor to the continued occupation of buildings in ways that lead to the decline in the conditions in those buildings. You've spoken to this at some length. Do you have anything to add in relation to that first proposed finding?
No, that it is on point both in relation to the housing questions and to the access to basic services question.
In 282, you speak to the city's failure to adequately plan so as to address the occupation of buildings, as opposed to being reactionary and say that this is a contributory factor to continued occupation. Do you have any comment to add in relation to that proposed finding?
I think the only comment that I would make, Chairperson and Commissioner, is that in our experience, it has been the absence of authority that has made conditions bad, and also to the extent enabled any criminal actions to happen. And we feel if the city was involved in buildings, then the consequences would have been mitigated. And so it's just that it's really important for the city to see itself as a government as having a responsibility in relation to the occupation of buildings in the inner city.
In 283, you move on to the question of criminal activity, and you say that while some buildings are unlawfully occupied, not all persons living in those buildings are criminals, building hijackers, or other forms of criminals. Indeed, the vast majority of residents or occupiers are not committing any crime. That's not an issue we've dealt with in great detail yet in your testimony. Do you have any comment to add on paragraph 283?
So I think the challenge is that there is a colloquial use of the term hijacked, and almost as a feeling. That's how responses from officials, politicians, and even other private property owners. So if the building next door to you was abandoned by its owner and the conditions are bad, you see it as it's hijacked, and you go as far, and we've experienced this, that you then give an instruction to Joboko to come and disconnect the water. And it's because this is just that word hijacked. It closes every door, it closes every eye, it blocks every ear. And unfortunately, if used in its correct legal understanding of people who collect rental for unlawful occupation, it would have been a completely different experience. But every building in the city is seen as hijacked, and the responses by everyone is that, to the extent that even buildings that have gone to seek assistance. So Fetis mentions it was a failed sexual title scheme, but it failed in the process where it had complaints, petitions, it had gone knocked on every door of the city. And just simply because of how the building looked, it was put on a path that says hijacked, and no one gave it attention. And so I think that's important. So this, I feel like the commission, in doing its work at the end, would really help us in also zooming in on the language and in acknowledging the humanity of the people who are in the inner city, so that this mentality of hijacked that makes everyone not care, not want to hear, not want to understand, not want to intervene, goes away.
You speak to that issue a little later in the statement too, and we'll touch on it in a moment. But the remaining findings in that section on page 133 deal with the role of building committees, and you've spoken to that in some detail and the role that they play. And in 285, on the legal framework, section 26 of the Constitution, the PI Act, and the city's policies around both housing and basic services, and how, again, issues of non-implementation are a key contributory cause.
Mr. Brickhill, I know I'm interrupting you quite at not so good a place, but there is a matter addressed with you why we should adjourn, but about now. If you find it convenient, please be alive to that.
Indeed so. I was alive, and I understand that we do need to adjourn at 1 p.m.
Yes.
I don't propose to deal in detail with this witness with the remainder on the lessons learnt and the steps to be taken. And perhaps it's best to perhaps I can simply have the witness confirm those parts of the statement.
Yes.
And then conclude
Yes, you
her
may
testimony
proceed.
through you, Chairperson. Ms. Zondo, the two remaining sections deal with lessons to be learnt and steps to be taken. And as indicated, these are to some extent provisional in that more evidence is still being led, but these were the considered position that you took on behalf of SERI in your main statement. And the lessons to be learnt are set out at page 134, summarized in paragraph 286. 4 main lessons: a better understanding of the authorities informing the social protected tenure arrangements, so a better understanding of tenure arrangements in the occupied buildings. The second one in 286.2, needing to clarify the real problems. The third, the EHP, the Emergency Housing Program, and you've spoken to that in some detail.
Yes.
And the fourth, the city needing to act proactively on its Section 26 PI Act and case law obligations, as well as its basic services obligations. And you develop those points around lessons to be learnt in the paragraphs that follow. In 287 to 289, you deal with the different forms of tenure and the question of occupiers being seen as the undeserving poor because they lack formal tenure rights in paragraph 289. From paragraph 290, you identify what you say are the real problems, and you refer to the following problems, the first being the issue of terminology that you've spoken to now around hijacking, syndicate, takeover in paragraph 292, the criminalization of the inner city poor. From paragraph 2, in paragraph 300, in paragraph 303, you speak to temporary alternative accommodation and the problems with its implementation, that it effectively becomes permanent because there's nowhere else to go.
Yeah.
And then you speak finally as one of the real problems to the question of non-implementation of housing and related policies, and you've addressed that in detail in your testimony. Your final points in the lessons to be learnt relate to the EHP. The city, you recommend, ought to make use of the EHP. And finally, from paragraph 308, that the city must proactively act on its obligations. I would just ask you then to confirm that you stand by those lessons to be learnt at this stage in the proceedings.
Yes, I confirm. I confirm, Chairperson and Commissioner.
The final part of your statement then makes certain recommendations on steps to be taken and by whom. And those, no doubt, will be matters, again, for closing argument and a focus there. But I would ask you to confirm that you stand by, at this stage, the recommended steps to be taken and by whom.
Yes, I stand by them, and I think, to be fair, SERI and the Inner City Federation stand by them.
Indeed. Chairperson, those are our questions in chief for this witness.
Yes. Thank you, Mr. Brickhill. These proceedings will stand adjourned until tomorrow at 10 o'clock.